COVID-19. Anna, we've been dealing with the pandemic for almost 2 years now. How do you think the legal sector has coped in general?
So our impression is that the sector's coped pretty well overall. Of course, it's been very, very different experience for different parts of the profession, but we certainly feel like our worst fears were not met, if you like. So I'm very anxious at the point of announcement and as we interacted with the profession over the first few months, but it seems to have landed well. It's changed. It's changed for the profession in ways that it's also changed for us as a regulator, because of course we've all had to get used to doing so much more virtually, and that's been particularly challenging for a sector which has not been known for its the pace at which it's adopted technology. For ourselves, I think the organisation managed to get online very quickly to adapt to the change, but we have really missed meeting people, and so it's a great pleasure to be here today.
I'm curious, what were your worst fears?
Sorry?
What were your worst fears?
Worst fears that it would have a very significant impact on the sector in terms of closures.
Closures?
Right. And that we would be, as a consequence, dealing with a rush of things which it was going to be very difficult to deal with virtually, and which was going to be very difficult for the profession and for the public who would not be able to access services. That doesn't appear to have materialised, certainly not yet. There may be a long tail effect, but we're optimistic, I think.
Okay, so Paul, how have firms managed to survive then?
Yeah, I'm on record, I think, of saying that there isn't such a thing as a sort of legal services market. There are lots and lots of different legal services markets. So if you're in immigration law or criminal law, then the nature of your practice is fundamentally different to if you're practicing in areas of corporate law. So as Anna says, what happened during the pandemic and lockdown is that the pain was felt in some places more than others. So if you were a criminal legal aid practitioner, you're probably feeling it pretty badly. If you were a conveyancer, actually quite surprisingly, you probably did okay. And if you look at the corporate law sort of profile, you'll see that the profits per equity partner seem to have actually did very well, thank you very much. So it hasn't played out the way in which you would have guessed that it might have. When we were speaking to local law societies, we heard a lot about the types of problems on the ground, obviously in criminal law, and with the closure of the courts, but in things like family law and in child protection proceedings where the courts were closed and people were being asked to bring their clients into their offices, and it was all right to bring them into their offices, but the government wouldn't let them into the courts in order to do video links, etc. And if you look at the technology perspective, yes, we as an organisation did okay, but we're reasonably chunky in terms of size. If you're a small organisation, you don't have the types of IT infrastructure that bigger organisations have, and therefore some of our research, we'll talk about a bit later, I suspect, was about what happened during the pandemic. And of course the types of progressive technologies people using are things like Skype and Teams and Zoom, and people are just getting to grips with that because their organisations are pretty small and don't have that type of infrastructure.
I mean, Anna, is that one of the biggest lessons that has actually been learned as a result of the pandemic, that more remote working is potentially the way forward? And what other lessons have you learned?
Well, I think that is the single biggest one, to be honest, Clive. I mean, I think talking to solicitors as we do, and as we have more and more as the pandemic progressed, we realised we could actually talk to solicitors in a virtual environment as well. And so the board has been having virtual sessions with local law societies to kind of hear how it is. And what we have heard is predominantly about the fact that lawyers have found that they are able to engage with clients using virtual technology much more easily than they'd anticipated. They talk about having progressed, sort of advanced 3 years in 3 months, sort of just having to develop that very quickly. And what we've also heard, and I think this is an unexpected outcome, actually, is that lots of more local practices have found that because they have boosted their virtual presence, and they are able to engage with people at distance, that actually they found some consumers in effect shopping around and coming to them even though they're not in that locality. So that's a new opportunity for smaller firms in a more competitive environment. So I think that is the single biggest lesson. But our research in this area clearly shows that the sector remains sort of in a place where it is using standard technologies to support back office functions and that sort of engagement. We're not yet, as a sector, really using technology to the greatest extent, and that's one of the reasons we're interested in working with the profession to help them to do that.
That's interesting. I mean, Paul, would you agree with that? And what are the key lessons do you think the pandemic has brought about for you?
Yeah, I would agree with that. The profession is incredibly diverse in terms of size and nature of law that people practice. And as I say, it's all about their level of infrastructure and the level of investment you can make in that type of infrastructure that depicts how well you grow as a business. And we're not seeing, and our research shows this, we're not seeing the types of leading edge type of IT that you would hope that you would see, and that certainly you see more in the financial sector than you do in law at this point in time. You're not seeing widespread use of learning algorithms or blockchain or anything like that. What you're seeing, as I said earlier, is the adoption of basic out-of-the-box types of software, because actually it's probably not been proven in the firm that it is worthwhile making that investment in terms of business utility. The other thing I would mention now, and I'm sure the audience knows this better than I do, is working online leaves you much more vulnerable to cybercrime, and that's a big deal for us. And hopefully you're all getting the various tweets and messages that we put out when we come across these types of things. But the reality is that the more you do online, the more vulnerable you are to this sort of thing. And the other types of questions that we've had in the past 18 months have really been about, well, how do you do client due diligence online? How do you do beneficial ownership of funds online? You know, when you don't actually see your client and you're only seeing them on your computer screen, it is much harder to verify who they are and where they got the cash.
That's interesting, isn't it? I mean, talking about law tech and innovation, Anna, because we're all encouraged to sort of, bank online. The high street is shutting down, many of its branches. We're encouraged in other parts of society to move towards, less paper, the speed of transactions online and all that kind of stuff, moving money between accounts and whatever. And yet you're saying that there is still an intrinsic barrier within the legal profession about client confidentiality and that kind of thing that seems to be blocking the move towards more innovation and tech. Is it just about that, or is it also about cost?
So this year we published some research which was done for us by Oxford University, and that looked particularly at what the barriers to sort of take up of technologies were. We've already talked about the fact that most people are using technology, but as Paul said, it's not the more sort of elaborate end of the spectrum. And what emerged were there were three barriers. One is cost, absolutely, finance. A second, really importantly, is skills in law firms, sort of both understanding of what could be done, but also ability to implement. And then the third, Paul's already mentioned it, is confidence that actually this is a road worth travelling, that there is a business case that stacks up. So actually, controversially, it's not about our rules, but the reason that we are interested in this space is precisely to try and understand whether our rules do get in the way, and if they do, how we can adjust them. So that bit we can address, and that's why we're doing pilot work, sort of supporting different types of funding for law firms to really get to grips with what the issues are that we might be able to do something about. I think the skills, the finance and the business case we can help with, but actually we need to work with others to help the profession to get up that learning curve.
Sure. I wonder if you've got any questions on the effects of the pandemic on your businesses and your work, or on tech. I mean, are you considering, moving more stuff online? Are you concerned? Is there more you think the SRA could do to help you with that? Any questions on that for our panel? No. You're all being quite down here at the front. If we can get a microphone to the young lady down here. If you could give us your name and your job title, where you're from, that would be great. Thank you.
My name's Julia Kent. I'm co-founder and one of 2 partners in a small high street practice. First of all, the Premier Property Lawyers experience has not encouraged people like me to start investing in IT. I'm surprised it didn't get a mention in your opening remarks. Also, if you have, as we have, an older clientele, we got people in the pandemic coming in to see us to sign documents because it was an outing for them and it was easier than getting a neighbour to sign something. And I'm told by our local building society they had people coming in all the time for book updates just so that they could see a real face. So it's a mixed picture. I was talking to another local partner the other day and she said that they'd refused to do wills for anyone who couldn't manage Zoom. And that seems to me not the way a profession should be going.
Yeah. Okay, thank you for that, Paul.
Yeah, so the firm in question wasn't an SRA authorised firm, it was a CLC authorised firm, but actually it's a classic example of the types of problems that you might trip over in terms of using tech.
Just explain the problems for everyone who may not be aware.
To be honest, I don't know the detail of it. I've only read what I've read in the papers, but I understand the firm went down with quite a lot of loss to client firms, to client funds. But as I say, I don't know the detail of it. But the reality is that it is about confidence. And I have to say I smiled when you said, the building societies people are keen to go out and into the world and actually see people, because I think that's all been our experience in the last 18 months. But the whole direction of travel, as Clive said earlier, in terms of banking, is online, and how you find different ways of getting verification of ID and keeping things secure. And the fintech stuff is much more advanced than we are in the legal sector, and it's only a matter of time before it happens. And I can understand why older people, of which I include myself these days, actually are more reluctant than younger people to use that type of technology. But it's a king canute type of thing. It's not going away. And Richard Susskind has been publishing books and doing the corporate circuit for a long time, saying the robots are coming. And I think he's probably right, but it doesn't really answer the question. The 2 key questions are, when are they coming and what does it mean? And actually what it means in this sector is far more online. I mean, I don't know about the last time anybody used a coin or paper money, but actually I find myself virtually not carrying any cash these days, whereas 2 years ago I did. That's a classic example of how quickly things change and how we acclimatise to it. And I think, although leaving aside the people aspect of it in terms of people going in and meeting people, I think the more and more will be done online. And the types of transactions which have traditionally required face-to-face contact and passports and ID checks will need to move with the times, and you'll find trusts and wills and stuff like that being done much more online in the future. Yeah,
I mean, Anna, just your response to that point.
Yeah, I just add, kind of looking at it from the consumer end. You're absolutely right, of course, that there is a group of consumers who really don't want to or don't feel able to transact online in the same way, and value that personal contact. I mean, look right to the other end of the spectrum. There's younger people just don't understand why you wouldn't. So, I mean, there are as many different requirements amongst the users of legal services as there are different types of legal service, or different parts of the legal sector, as Paul was talking about earlier. And of course, if you add into that mix businesses as clients, many of whom are absolutely enormous, of course, and very well used to operating in a more virtual environment. So you know, the key is that the legal sector needs to be able to respond to all of those needs, both those who aren't yet there or never will be, and those who are absolutely itching to be at that kind of virtual environment. And I think one of the things that is most important for us as a regulator, given the various statutory objectives we have, is the way in which this technology might actually increase access to justice, because we firmly believe, and I think so do many solicitors, that if we could find ways to engage with people to help them understand that they have even got a legal issue, and give them a way to begin to unpack that, such that if they need to, they will then talk to a solicitor, then this would be a great advance in terms of access to justice, and we think technology has a great part to play. Of course, so do more traditional advice services, but technology has a big part to play, and I don't think we've really begun to deliver on that yet, and it's a key focus for us.
Yeah, I've got a good question here from Brian Rogers. Many law firms don't know the questions to ask of IT companies in order to get the best product. Unknown unknowns. Should the SRA help firms with questions, Paul?
Yeah, I mean, it's a classic manifestation of the fact that if you're a relatively small business, if you're a man or woman band, or indeed just a very small firm, you don't have that type of expertise. As a matter of fact, when we were developing the Solicitors Qualifying Examination, which I'm very pleased to say went live a couple of weeks ago, we had long discussions with law firms up and down the land about whether or not qualifying as a solicitor, a core competency of which should be getting to grips with IT and understanding, could you code, can you develop apps, that type of thing. We came to the conclusion that who knows what the future brings, but the start has to be about the core subjects that you would have done on the law degree, or indeed on a conversion course. So we decided not to do so, but there was a classic example of people recognising that in the practice of any small business, and laws is often a small business, should there be IT competency at the point of entry. And we came to the conclusion, probably not for now, but you can see that in the future it will develop very quickly into it's nearly impossible to practice law, particularly in a small firm, without having that degree of competence. To answer Brian's question, I don't really think it's for us to provide guidance on how IT is procured. That's not our business. Our business is to regulate the profession and to help it grow. It's very much for the profession to decide how it runs its own business.
I mean, I suspect Brian might have been suggesting, and I apologise for putting words into your mouth, Brian, but Anna, he might have been suggesting that the SRA damn well should be helping if this is the future.
Yeah. So I think this goes to the heart of a really an issue which we've been discussing as a profession, I think, for a long time, which is what the respective roles of the Law Society and the regulator are. And technology is one which absolutely sits in the space of, well, there's something for both of us here. So you know, our primary interest is going to be around things like making sure we don't get in the way. I've talked about that already. Making sure we flex and adjust our rules, but still deliver the right kind of protections for the users of legal services. That's a really important part of what we're doing. We're also really interested in what could be delivered in relation to access to justice. We want to understand what the issues are. That's why we did the research this year and put it out there so that people can see what the issues are and how they might be addressed. We don't pretend to be the body that can then address all of those issues, and there's a really important role for the representative body, for the Law Society, and indeed actually for the training sector, a real opportunity for the training sector to offer additional training around things like IT for law. So we are not the sole show in town, and if we were, I promise your fees would be a whole lot higher. So, you know, the fact is we need to work with a variety of others using the evidence that we're putting in that public domain. And that's actually, if I go to our corporate strategy, so we you know, I hope you will know, we've got 3 objectives in our corporate strategy. One is, you know, all the stuff around standards. A second is around tech. But the third is very much about speaking out about issues, particularly looking at the horizon, speaking out about issues, particularly where it's clear that we are only part of the solution, and then working, collaborating with other organisations. And that's exactly what we do with the Law Society and tech space, and in relation to training with academic and other institutions who can support the profession. So it's a more complex picture.
All right, okay. Please, folks, if you've got questions, got queries, you can do it anonymously via the app. If you really want to get some answers out of these guys, because they know the answers, we all hope, to all of your questions, think them up. Come on, we've got lots to talk about next half an hour or so, so we really want you to be involved. Let's talk about the Solicitors Qualifying Examination. Paul, you mentioned this. This month has seen the first ever sittings of the new exam, the SQE. How's it gone? Has it been a success?
Yeah, we are really pleased. SQE has been a long time coming. So there was a legal education and training review in 2012 that was co-sponsored by us, the CLC and SILEX. The whole idea was to set an agenda for change in the regulatory framework associated with education. And it's been a bit of a journey for us. And most of you will know some of the components of that journey. So for the first time, we set out the competencies to be a solicitor on day one. We dealt with CPD and really the game of collecting points for CPD, and the whole idea that if you get 3 points or 6 points for listening to someone like me, then that means that you're up to date and fit to practice, which of course it doesn't. And it drives a compliance industry of conferences such as this. So actually we abolished that, and we need to come back to continuing competence as to whether or not the position is as good as it should be. But the jewel in the crown in our education agenda was SQE, and for the past 5 years we've been developing how SQE would work and how it would supersede the legal practice course in qualifying to be a solicitor. The Legal Services Board agreed all the arrangements a couple of years ago. We have spent the last year making sure, working with our partner Kaplan, to make sure that actually the assessment went as well as it could do. So just under 1,100 people sat the first sitting of the Solicitors Qualifying Examination Part 1 at the beginning of the month. All of that seemed to go incredibly well. The results are due to be published on the 24th of January, and we'll see what that brings. But it's gone really well, Clive, and we're really pleased. It's obviously we've got to the end of the beginning, and the next bit is Part 2, SQE Part 2. So in order to qualify as a solicitor now, you really need to do SQE 1 and therefore and then SQE 2, which is essentially a skills lab. And that will happen, this first sitting of that will happen in April next year. So far so good, we're really pleased about it. Those numbers are tiny compared to the amount of people who will actually sit it going forward. There's probably something in the order of 8,000 to 12,000 people a year will sit that examination, so this is small beer in comparison, but it's a good start and we're really pleased.
Okay, a good start. I mean, Anna, most people in this room will have already qualified unless they're incredibly good blaggers. But what role can law firms and solicitors actually play in making sure that SQE is a success, do you think?
So our abiding hope, and it is a hope, is that we are providing a way in which the route to becoming a solicitor can create more diversity in the profession, that you can be confident no matter how people have gone through the qualification process, they are at the same standard as each other, which should mean that you no longer need to even look at where they did their degree, if they did a degree, or any other signs that you might previously have relied upon to give you a sense of quality. The determinant of quality is whether they have passed SQE1 and SQE2 and done the required qualifying work experience. So we are depending, if we are going to achieve our diversity objectives, we are frankly depending on law firms working on that basis. And we hope, therefore, supporting the idea of creating a more diverse profession. That's why we'll be very transparent about both how SQE works, what the pass rates are, etc. But most importantly, and this is very close to the board's heart, doing the sorts of evaluations which will tell us whether or not SQE is delivering on what it promised, on the outcomes that we set out to achieve. And we've this year commissioned an evaluation partner. The first of those evaluations, I imagine, will probably be next year over a 5-year period. This is going to be a long haul because you don't see the results in a short space. But we'll be setting up the evaluation framework, and we'll be obviously sharing with the profession what we learn as we go through that evaluation process.
I mean, Anna's brought us onto the topic of diversity, Paul. I mean, it's still a big problem, isn't it, in this profession, particularly at senior levels. In larger firms, SQE is part of the solution, potentially, we hear. What more is being done to make this profession a little bit more representative of the majority of people who end up becoming clients of these firms?
Yes, you're absolutely right. More needs to be done. You find a greater propensity of people from non-white backgrounds, if I can call it that. In smaller firms, you see a lesser propensity in bigger firms. We're seeing more and more partners and senior partners who are women these days, but it's only the tip of the iceberg, as it were, and there needs to be much more. So I think in gender diversity and in sort of ethnic diversity, we would definitely like to see more people hitting the top of the very big firms, and you will see lots and lots of people from various minority groups and smaller firms who are giving a hugely valuable service to the community, but more needs to be done. One of the things that we're doing is, that which is sort of counted. If you count things and you measure it, then you can see whether or not there's been a change. And every 2 years we voluntarily collect information on the diversity of the profession from yourselves. And we've just finished that exercise, and hopefully we'll be publishing that shortly in the new year. But it's been really important because then we can see what the actual stats are rather than what the anecdote is. And SQE, just to go back to that, does play a significant component of our overall inverted commas plan. As Anna said, you will be assessed independently regardless of how you entered the profession, or whether you went to Oxbridge or Russell Group University, or whether or not you did a SILEX route or indeed an apprenticeship. And if my marks on SQE are better than yours, Clive, then actually when I go for my interview with Big Firm Limited, I would hope that they would accept me rather than you, or vice versa, regardless of any other demographics that we actually have. So that is a real opportunity as being a leveller to see a further generational change in allowing people from disadvantaged groups of whatever type to actually get to the top of the profession. Yeah,
it's a really interesting point, Paul, isn't it, Anna? Because Tony has sent in a question saying, how are you defining diversity? It's not just got to be on race or gender. It's got to be on socioeconomic conditions as well. White working class boys getting into the profession too.
Yeah, so one of the things that we did, I'm not sure whether it was last year or the year before, was to restructure our data collection so that we collected better data about social mobility, or to support work on social mobility, and because we absolutely recognise that that's important. So our work on diversity covers all the protected characteristics and more, and part of what what we do is to sponsor, to facilitate conversations across the profession about what the profession is learning, what different firms are learning about what works. So last year we did a series of webinars, virtual of course, which I chaired a number of them to bring together firms and experts to talk about their experience of trying to address particularly the progression question that you're raising, Clive. So not just about entry, that's SQE is helping, we hope, will help with entry, but progression through the firm, looking at things like mentoring initiatives, as I'm sure some colleagues in the audience will know, some of the big firms are setting targets. Will that help? I don't know. But these are live experiments, and we need to monitor them and share our experience. There are many different things that can be done within solicitors' firms, and we're really interested to hear about them and want to play our part in spreading that sense of what works.
Sure. Okay. Any thoughts from the floor? Questions on SQE, on diversity? Do you believe that the SRA perhaps could be helping out a little bit more in trying to push diversity in this field? Any questions out there? You're so well behaved this morning.
I think it's too early in the morning.
It's too early, isn't it? It's way too early. Okay. Well, we've got a question here from G. Just says G, Daddy G, Baby G, just G. SRA has made great strides on policy and education. Enforcement still seems a bit uneven, Paul, with questionable outcomes, costly with delays. What needs to change?
It's a good question. So our enforcement work has evolved, not of our own making, but if you look at the nature of the cases that we find ourselves prosecuting, if you can use that term. If you went back 10 years even, you'd find that 99% of our work was about misuse of client funds and mishandling of client account. Excuse me. And if you look at the way in which those are prosecuted, it's a kind of desktop exercise. You look at the accounts, you get a forensic accountant in, you look at whether or not there's a deficit, you attribute that to something or other. Incompetence, dishonesty, whatever that might be. But it's a fairly straightforward type of thing to investigate. If you look at the nature of a caseload now, you look at bullying, abusive position, sexual misconduct, misuse of non-disclosure agreements, anti-money laundering, misdemeanors, I can call it that, as well as the sort of basic dishonesty, which isn't prevalent in the profession, but tiny amount of people bring down the vast majority of the good folk. You will see that there's been a complexity evolved over the last 10 years, which is fairly unprecedented in the history of the SRA. And for those of you who do any litigation, you know feel well and much better than I, that prosecuting a matter where you're relying on live evidence in terms of witnesses is much more complicated than the desktop exercise that I've just described. So it's taking longer, it's costing more money, and actually it's leading to more stress and more delay. And we have plans afoot to deal with that, and one of them is of course what we went out to consultation on last Friday, which was when and how financial penalties should be given in the disciplinary procedures.
Oh, okay. Ladies and gentlemen, if the Director General of the BBC was here, I'd have a hell of a lot of questions for him. I cannot believe we've got two leaders here of the SRA and you've got bugger all to say so far. Frankly, I've got loads of questions here, but we want to see some action on the floor as well. We're going to get on to fining powers, Anna. You've just launched a consultation that proposes increasing fining powers to 25,000 quid. Why is that necessary?
So, perhaps I'll start by saying, of course, we've got 8 years' experience of operating this, the arrangements that are in place at the moment, and we've learnt a lot. So, we like to look at the evidence, and the evidence shows that a very large proportion of the cases that end up having agreed outcomes are attached to penalties of 25k or under.
Right.
And we know that if we deal with these things within the SRA, we can deal with them, as Paul has just described, in a more timely way, with hopefully less stress. That means that we think it would be better for the profession, better for the public, for us to have increased finding powers to deal with those things. I should add that, of course, anyone who wanted to dispute those outcomes could, of course, still go to the SDT. That's always, natural justice prevails. You can still go to the SDT. But for many cases, for many individuals, it seems that this might be a better way. And of course, what it also allows, and I think this is hugely important, is for the SDT then to focus their energies on disposing of other cases in a hopefully swifter manner, and that must be a good thing too. So we come at this by looking at, so we've got a framework which involves us and the SDT, and this seems to us to be a more efficient and effective way to deal with these issues. That's our proposition. And we are very keen to hear what people think about it, not least actually, of course, the SDT itself, the tribunal itself, because it's important that we find the best way of arranging ourselves as partners in this exercise to meet the needs of the profession and the public.
Okay. Paul, you mentioned alluding to anti-money laundering and how it's important that the SRA helps firms deal with that. Insurance as well is another important issue. And we've got a couple of questions submitted by Kolawole and Lijo on insurance. They're both concerned about the rising costs of insurance on firms, particularly smaller ones. Again, how is the SRA involved in trying to help that situation?
So we all know the position with professional indemnity insurance. We moved away from a market policy arrangement around about the turn of the century towards a market arrangement, so a master policy arrangement away to a market arrangement, whereby you get access to PII off the markets. And markets go through good times and bad, and what we're actually seeing in the last few years is a general hardening of insurance across the piece. My car insurance was more this year than it was last year, despite the fact that nothing's happened during the year. So it is hardening, and I'm sure the pandemic has not made that any easier. What we know as the regulator, essentially holding the ring, and we are the people who define the minimum terms and conditions, and that drives a lot of the premiums, is that despite the increase in insurance for firms across the piece, the amount of people who are not getting insurance has not gone up. So last year there was the same amount of people who closed because of not getting insurance as there has been in the previous years. And this year it's looking even better than that. It's looking like the amount of people who are going into runoff as a consequence of not getting PII is even less than it was last year. So there's no doubt that people can get indemnity insurance. And in terms of what we would do about it, the real question is, when would we attempt to intervene, and when would we think about changing our minimum terms and conditions? And I suppose the answer to that is only if we begin to see market failure. Right. And actually, we're not seeing market failure. Now, I don't deny the fact that you're probably paying more for your professional indemnity insurance, but the insurers would argue that you'd be paying less for a long, long time when the market conditions are really good. And therefore, actually, you have to take the rough with the smooth. And actually, we are monitoring it, and we will keep an eye on it, but we have no intention of intervening at this point in time. The other thing is that the Legal Services Board are interested in this, and they'll be doing a piece of work to review that, and we are very happy to work with them to see where we get to. But right now, all of the evidence, as opposed to anecdote, that we see is that, insurance premiums are going up. It's probably hitting profitability of firms across the piece. But actually, as a regulator, we would only really intervene if we started to see so much market failure that it impacts on one of our regulatory objectives, such as access to justice.
I mean, this question from James, what systemic steps are being taken to ease the burden of professional indemnity insurance, which will help competitiveness, including investment in cutting-edge tech? I suppose it goes back to Brian's question about the SRA's role. What are you doing to ease the burden on firms out there when it comes to insurance, Anna? There is a sense that perhaps you should be doing more.
Well, I think this goes back to the set of objectives that we have. So we have both an objective about the market, the state of the legal sector, and we have an objective about appropriate consumer protection. And we have a number of other objectives, of course, statutory objectives as well. But every decision that we take is, in every decision that we take, we are seeking to find the right balance between those different objectives. The minimum terms and conditions that we set for PII are set with that in mind. So what kind of protection do the users of legal services need? And how can we establish the right level of minimum terms and conditions such that we don't create market failure? And as Paul has said, we don't see market failure. So we see no reason to go back to whether or not the minimum terms and conditions need to be changed. But this is a delicate balance, and one that we will always have under review, as we do with all of our policy positions. And you know, we certainly engage with the insurance sector, who are quite vociferous sometimes about their desire to see us reduce the minimum terms and conditions, because they would like to do this in a different way. I just go back to we're in this delicate balancing position. As we stand, it does not look like it's necessary.
Okay. This question is from Peter. How do you think the profession overall is coping with principles-based regulation versus more rule-based regulatory systems?
That's quite a good question, and it does go to the previous question. So I was thinking as Anna was speaking, you know, what are we doing to make sure that there's a competitive marketplace, and that actually overheads such as PII insurance are kept as low as possible. As Anna says, the insurers have made representation to us across the board to dilute minimum terms and conditions. And of course, you've got to remember the reason why they're there is for the protection of clients and consumers. And actually, the number one term that they would like to be removed is the 6-year runoff cover, because actually they price that into premiums, and they say if we didn't have that, then actually premiums would be less. But for those of you who've been around for a while, you know that we proposed changing minimum terms and conditions about 3 years ago, and actually all of the consultation responses where don't do it, and therefore we didn't do it. And actually what you're actually seeing is to some extent a consequence of that. But what else have we done to reduce burden and cost? Well, we introduced principle-based regulation so that there is less compliance, and therefore actually people need to spend less time looking at compliance, and they need to use their judgment. People, particularly lawyers, if you don't mind me saying, prefer rules, and they would like to say, look, here's a rule, I'll comply with that. But actually, all you really need to do is act reasonably, and I know that that's a bit of a dirty word because it's open to interpretation. But actually, if you act reasonably, well-intentioned, then actually we will treat you as such. And therefore, actually, from our perspective, particularly during the pandemic, actually that has worked quite well for us, and we think that so far so good. We've got evaluation of that particular initiative in hand, and we're going to be publishing some of that shortly, and we're doing sort of 1 year, 3 year, and 5 years to see how it goes. But the other issue that we thought about when we were looking at burdens in terms of people practicing law was the idea of different practice contexts. So we introduced the whole idea of freelancers for reserved and non-reserved work, 2 years ago now. I can't remember the actual numbers. There's a few hundred freelancers in the country at the moment. But quite a lot of what you can do can be done as a freelancer with far less business overheads associated with regulation. And I'd encourage you to have a look at that, because those two things are definitely things that we've offered to the marketplace in terms of reducing business overheads and thinking about things like PII, because you have different PII regimes for freelancers as you do for regulated bodies.
Sure, okay. We did have a question a little bit earlier from Big Daddy G. We have a question now from M. Judi Dench has changed profession. I'll put this one to you, Anna. There is a perception in smaller and ethnic minority firms that they're targeted by the SRA for inspections and enforcement. Will the SRA publish data?
So I believe we do publish data, and actually...
And what's it say?
Well, what it shows is that there are a disproportionate number of cases that come to our front door, which involve black and ethnic minority solicitors, and we are, frankly, not happy with that. And one of the things that, because we don't understand it. I mean, if it was, if there was an explanation and it was legitimate, we would absolutely, want to do what we could to support those people as they go through the process. But we don't understand it, is the honest truth. We don't know why there is a disproportionate.
The firms might feel they understand it. It's because they're black.
Absolutely, and that's what worries us too. And so we have we're in the process of commissioning some research, which will help us to turn over those stones and understand why it is that that's the case. But I reiterate, this is what comes to our front door. So this is on the basis of complaints that that are made, which we then are required to investigate. And we've looked at whether or not, once they move through our process, we introduce any more disproportion. And actually, the figures stay pretty much the same all the way through the process. There's a bit of a little bit of change, but we've done quite a lot to try and enforce improve our enforcement processes. So the fundamental problem is what comes to our front door, and we have committed to investigating that, and of course we will then share what we find and our plans to address it, because you're right, it might be. I mean, there are so many different versions of why this might be. It might be because, as we know, there's a disproportionate number of black and ethnic minority solicitors in smaller firms, actually.
So why
it might be smaller firms that are
Okay.
more prone to problems.
Right.
It might be simply because those solicitors are black or Asian, and people feel better, they feel easier about complaining. Who knows? We just do not know, and that's what we want to find out.
Okay, but that's interesting you mentioned the smaller firms, because a number of people have got in touch to say, what are you doing to make sure it's not just small firms or junior solicitors who are getting hit hard by enforcement? There seems to be a pattern here, Paul, which is not very edifying.
I mean, I think we need to look at the evidence. The vast majority of solicitors' practices in this country are relatively small businesses. So there's, I don't know the exact number, it keeps changing, but there's somewhere between 10,000 and 10,300 firms in England and Wales. And actually, after about the top 200 to 250, they get down to pretty small firms.
Right.
And
so that's just the general makeup
it's just
of
the
firms
general,
anyway.
I'm afraid the general hoi polloi
Okay.
of firms is that they're relatively small businesses. And the other interesting statistic is that 40% of all practicing solicitors, so they say there's 150,000 practicing solicitors, 40% of those work in the top 200 firms. And this goes back to the point we were making earlier about diversity and fairness, and more needs to be done, because actually, so of that 40%, I think I'd hazard the guess that if you were to do the research, you'd find that in terms of progression, most people that get to the top are male and most people are white. and it takes you right back to that type of thing.
Discussion, yeah.
But this is a sensitive and rightly a sensitive topic. But if you look at all professions in the world, and certainly in England, if you look at doctors, if you look at architects, you look at accountants, you look at solicitors or barristers, you find the same profile. Now, that doesn't legitimise it in any shape or form. But as Anna says, it is insufficient that we don't understand it, and hence we're commissioning research to understand it. What we do know is that actually, because of the propensity of people in smaller firms to have a higher proportion of black and minority ethnic folk, what we're seeing is that of the 10,000 or so complaints about solicitors that we get every year, there is a much higher percentage of people from, if I can use the terrible acronym BAME, with all its limitations, a lot more of those are being referred to us. And actually, when you look at the nature of presenting complaint, it looks serious and you have to do something about it. And as Anna says, as you go through, you'll see that actually it evens itself out quite well in the process. But going back to the stress and the time and the perceived disadvantage, what is a disadvantage, but the perceived prejudice that actually might be suggested at the front end, it is unacceptable. And therefore more needs to be done about that.
Okay, so just to be clear then, you're saying that the majority of the complaints made about solicitors in any given year or in the last year or so are against firms that are predominantly BAME?
Now, what I'm saying, nearly, what I'm saying is that if you look at the percentage of BME people compared to the percentage of BME people who are in the general population of solicitors, they are higher than they ought to be.
Right.
So basically, it's not the majority.
Yeah. So as a percentage, but
as a percentage.
Proportionately,
It's
way higher.
Disproportionate.
So it's right.
So the real question.
Why is that?
Well, that's what we want to
And that's why
know.
you need to ask.
Yes.
Well, are you looking into it?
Yes.
And have you been looking into it? How long have you been looking into it?
Yeah. First of all.
Well, no. How long have you been?
No, I'm going to answer. Hold on. First of all, the problem is encoding, and actually we've had, as I think most of you appreciate, a fairly wide-sweeping IT project ongoing for about 5 years at very, very significant cost to us and to you. And the coding had to be suspended whilst we'd done that. Now that we have it, as I said earlier, we're collecting information on a 2-yearly basis, and we're getting the information on people who are coming into the firms and who individuals who are coming into our processes in order to map it. We're commissioning research to try and understand that. So there's 2 pieces of research that we're commissioning, which really go to the issue of diversity. One is in relation to why is there a disproportionality of people coming through the door into a disciplinary work, because it looks really odd and we don't understand it. And the key question there is, should there not be more white people referred in? Because the people who are referred in look as if they have a legitimate case to answer, whether or not it's ultimately proven. The real question is, shouldn't it be a balancing amount of white solicitors referred in?
Yeah.
And the other issue, which is a different manifestation of a similar type of thing, is that if you look at qualifying examinations or assessments for professions across the globe, and particularly in relation to solicitors here today, you will see that actually people from minority groups do not do as well on licensing examinations as white people. Why is that?
Proportionally.
Proportionally. Why is that? So we're commissioning research into that. I think I'm right in saying that we've just commissioned Exeter University to look at that, and following hot on its heels with this other piece of research looking at the issue that Anna's raised, which is why is it the intakes into our disciplinary procedures are disproportionately laden from people from black and minority ethnic groups? Because there is something going on there. What we do know is that the nature of the presenting complaint is serious and requires investigation. Once it's investigation, that narrows itself out, and actually the proportions are quite good at the back end. But there's something about the intakes that we need to look at, and that's what we're researching.